Welcome to the annual Southeastern White Collar Crime Institute, sponsored by the ABA Criminal Justice Section. And now we will hear from Brian Mcavoy. Brian?
Thank you. Thanks, Patrice. As Patrice said, I'm Brian Mcavoy. I'm with the Government Investigations Practice Group of Olson-Ellie here in Atlanta, and happy to be joined by my colleague Joe Whitley today. Although we had different plans and had hoped to be at Chateau Elan for our 7th annual ABA Southeast White Collar Crime Program, as I'm sure everybody's getting used to these Zoom meetings, and so we wanted to kind of get everybody together and at least give an opportunity to talk about some Southeastern updates. But before we get to our panel discussion, Joe, I wanted to talk a little bit about our program and the background of it. As I said, this is something we've been working on for about 7 years now. It's really grown over the years to not just include our friends in the Southeast, but really folks from all over the country.
Yeah, Brian, it's really become a great national program. We have attracted over the last 6 or 7 years some great national speakers, leaders from the Department of Justice, people around the country who are experts in their field. And really the credit for this program goes back to Ray Benoon, who actually started the big white collar program that happens in March. But we thought we'd take this program and move it to a regional program. And Ray, of course, has been a big participant in the program, and we've had great support from the ABA. Not on this, I think maybe on this call is Carol Rose, Regina Ashman, and Patrice Payne with the ABA have been wonderful. And then, of course, my assistant, Holly Hampton, who may have a word or two to chime in, has contributed over the years. So there's a lot of labor that goes into this. And this year we don't have that opportunity, but we wanted to thank those of you who are with us, because the momentum of the program really are the participants that have been part of this program year in and year out, Brian.
Well, and Joe, I know you're someone that doesn't need an introduction, but I'll give a brief one anyway. You have always been someone that I've looked up to, and being a U.S. attorney in 2 different districts and spending time with the DOJ and really being a leader of the Atlanta white collar bar for some time. And I've always appreciated working with you and doing this program. And this will be the first year we'll be doing it without our friend Mitch Mitchelson, who retired from Alston and Byrd last year. But as you said, we wanted to get together today, if even virtually, to see so many of our friends and colleagues that have been big supporters of the program. And the thinking behind doing it, just outside of Atlanta at Chateau Elan was really to have kind of a captive audience where people might, want to stay and enjoy the camaraderie and the dinner, particularly Thursday night at the winery. And I know next year we're all looking forward to post-COVID times where hopefully we can rejoin in person. And I know that's something that you really enjoy.
The social part of our program really is the highlight. So many people get a chance to meet firsthand. Usually we have all the U.S. attorneys from Georgia in attendance, and federal judges from Georgia in attendance. So that is an opportunity to see people in a social setting. You don't get a chance to do that too often, and I think that's a big part of it. This next year's program, I believe, is September 8th through 11th. 2021 at Chateau Elan, and seems so far away. That's why having this call today with everyone is a great opportunity to kind of keep people focused on how and when we'll have our next program, Brian.
Well, I know we're all looking forward to 2021 for a variety of reasons. But from the ABA perspective, we were all disappointed that for the first time in 30 years, we didn't have our in-person national program. That's scheduled to be in Miami in March, and hopefully we'll be able to meet in person in some capacity. But Holly Hampton, would you mind just giving a little bit of the logistical details about the Southeastern program coming up next year?
I'd be happy to, Brian. Good to see everyone. I wanted to let you know that, again, please mark your calendars for September the 8th, 9th, and 10th at Chateau Elan in Brazelton, Georgia, we will be sending out, Carol Rose from the ABA will be sending out an announcement to all of our attendees, our prior attendees, about the program, how to register early. We encourage you to register early for the program to get a substantial discounted rate. And we just really look forward to seeing you next year. It's going to be amazing. The pricing is going to be the same, but our program is going to be even stronger coming up, and we're looking forward to seeing you. Thank you, Brian.
Thank you, Holly. Well, without further ado, I'd like to introduce our great panel today. All of these folks were slated to be in person in San Diego, but really grateful that you all could reconstitute as a group and join us today. First is my friend and colleague, Jamila Hall, who's a partner at Jones Day, a trial lawyer, handles internal investigations, white-collar criminal matters, healthcare matters. Jamila spent time as an assistant United States attorney in the Northern District of Georgia. I've had matters against Jamila and with Jamila. I prefer the matters with Jamila. But Jamila has been a huge supporter of the Southeastern program, and it's always great to see you, and thanks for joining us today.
Thanks so much, Brian. Glad to be here.
Also joining us is Erica Barnes from Maynard Cooper in Birmingham. Erica is also a former federal prosecutor spending time in the Northern District of Alabama and has a similar track to Jamila in her current practice handling internal investigations, white-collar criminal matters. And you know that Erica has really earned her stripes when you find out that she clerked for the late, great Judge Owen Forrester. So we're happy to have you here today, Erica.
Yes, thank you, Brian. Glad to be here.
And then last but not least is JD Thomas, who's with Waller in Nashville. JD was a federal prosecutor and assistant United States attorney in the Middle District of Tennessee. JD has particular expertise on the False Claims Act side and healthcare matters. And looking forward to hearing from JD about sort of what's been going on in the three districts in Tennessee.
Thanks, Brian. Very excited to be here.
What we thought we would do is sort of, take a trip around the Southeast. Originally scheduled to also be with us was Jane Raskin from Coral Gables, Florida, and Ann Tompkins from Charlotte, and neither were able to join us. So we'll try to touch on some Florida and North Carolina matters as we go through. But what we thought we'd try to do is just start with each panelist to kind of get a sense of things that have been going on of interest in their home districts and home states. We did prepare materials, I should say, they prepared materials for the program in San Diego. So a lot of what we'll be talking about, at least initially, is kind of pre-COVID. And then after we go through some substantive case updates, we thought we would talk about sort of COVID response, both nationally and in the Southeast. So Erica, why don't we start with you and kind of just give us a sense of what's been going on in the Northern District of Alabama and elsewhere.
Absolutely, Brian. So when we were getting ready to do a 2019 review, 2019 in Alabama was a heavy year for healthcare prosecution, as I think it is everywhere, but particularly here for opioid-related prosecutions, both traditional pill mill cases and then also healthcare fraud and money laundering cases with a sort of opioid component. I've listed a number of those in the materials. We had several trials that happened in 2019, and then that's continued through 2020. So I tried a matter in January of 2020. That was an opioid physician matter. And then a number of the 2019 cases that are still out there have resolved now in 2020, even in a post-COVID environment. So we anticipate that's going to continue into 2020. It's being driven largely by the Northern District and the Middle District of Alabama, with some cases in the Southern. We've recently had a change in U.S. Attorney here in the Northern District. J-Town has resigned that position, and Prem Escalanda is serving as interim U.S. Attorney. So J-Town had a particular passion for those issues and a particular passion for opioid cases. So I don't know if we'll see that waning. but a number of those cases have been sentenced with physicians getting really, really significant sentences. The Patrick Afetiba case was finally sentenced just here recently. 61-year-old physician received a 30-year sentence and a multi-million-dollar forfeiture order. So, but we're seeing some more moderate sentences. We had a case in the Southern District where a physician received a probationary sentence. The matter that I tried in January, we went through a 2-week trial and were able to plead to 1 count while the jury was out and get a probationary sentence in that case. So we're seeing some more modest resolution, but some really significant sentences for physicians. And I think that will continue. We're also continuing to see the tail end of the compounding cases. I know we all feel like we've been dealing with those now since 2014, 2015, but the global prosecution here in the Northern District, I believe they're now up to 25 or 26 defendants that are resolving that case. And we're seeing them go after physicians, pharmacists, medical sales reps, company executives. It really spans the spectrum. And again, some pretty significant sentences in those cases as well. There's going to be some personnel change in the healthcare fraud coordinator role here in the Northern District this year. So we don't know if those compounding cases in that prosecution will finally sort of fall off. Outside the healthcare context, your traditional employee embezzlement, tax preparer cases, we're seeing some, some more complex schemes, but the focus really seems to be on healthcare, and again, anything with an opioid nexus. 2 other things of interest that happened in 2019/2020. The Mike Hubbard case that has, if anybody has been following that since 2016, that was our former Speaker of the House who challenged the state ethics laws, and that's been moving through the court system now for 4 years. So the Alabama Supreme Court has finally denied every level of recourse there, and has ordered, I think as of 2 weeks ago, former Speaker Hubbard to report to serve his 4-year sentence on that case. People were really actively watching that, I think, to see what the courts would do in terms of defining the Alabama ethics laws and some of the discrepancies and confusion in that law. So we'll see what happens there. That seems to be the primary push of the Alabama AG's office. So outside of the federal side, we're mostly seeing public corruption prosecutions in Alabama. That seems to be the primary thrust. The other thing people are paying attention to is the 11th Circuit finally resolved AseraCare. I know many of you have watched that.
Jack Selden probably has mixed emotions about that case being resolved.
He'll be pitching for a lot of false claims work for the next 10 years. But those are the primary things we've seen in Alabama, and I would encourage you to look at the materials that we put together, and I'll be glad to take any questions.
Well, Eric, it's interesting, a couple of districts seem to be the tip of the spear in the compounding cases, right? And Northern District of Alabama was certainly one of them. And then along with many other districts, you talked a little bit about the opioid cases, which have also evolved. And it's interesting to see the criminal prosecutions evolving from sort of the Title 21 stuff to the theories of liability more consistent with healthcare fraud cases.
And that's also where we're seeing the disparities in how serious the cases are. Again, the Afetiba case, where you're looking at a 30-year sentence, it was primarily driven by the healthcare fraud piece, with opioids just sort of being a way to dirty up the defendant, for lack of a better word. And we saw that also in the Dr. Roberts prosecution that just pled recently. sort of using opioids, but then coming in with more traditional kickback, compounding, other types of healthcare fraud theories. And so I think that will continue. I think opioids are sexier for juries, and they're certainly more attractive for prosecutors. So we're seeing these combo cases of opioid issues with traditional healthcare fraud.
Well, and I think with the, a lot of civil litigation and multi-district litigation around opioid targeting manufacturers will continue to spin off those types of cases. I wanted to note at the outset, I failed to mention that if anyone does have questions, there is a Q&A function at the bottom of your screen. Please feel free to ask questions, chime in with comments or observations as we're going forward. And I appreciate that summary, Erica. If we move over to Atlanta, Jamila, if you and Joe could kind of walk us through, not just what's been going on in Atlanta, but and throughout the state.
Sure, Brian. Well, it's great to see everyone. And as I remember very fondly, last year I was celebrating my birthday with you all at Chateau Elan. And so I don't have that this year, but somebody sent me a balloon I wanted to show you. So, let me grab it. It's a little thing, and it actually sings. Anyway, I don't know how to make it stop though. But
well, happy birthday from all of us.
Thank you. It's great to be here today, and I wanted to share. There's actually a lot that's been going on even during COVID in the Northern District of Georgia, and something that I want to share with this group in case they have a need from their client concern. Trying to move this balloon out of the way. So I'm actually going to start with that, Brian, and then I'll go over some things that have happened in the year. But in the middle of COVID, we were negotiating on behalf, trying to negotiate a resolution with the Northern District of Georgia, and the U.S. Attorney there, B.J. Ponk, just decided that they were done and negotiating with us, and we reached a stalemate. And it was to the point where we really decided we needed to go and take an appeal up to the DAG's office. But doing that in the middle of COVID, when everybody's working from home, and was a little bit scary at first, but it actually worked out quite well. I was able to find out through a colleague who the folks in the PDAG's space were, reach out to one of them, and then we prepared a pretty strong written appeal that did catch the attention of the DAG. And then we were given a 1-hour session with the DAG's office, where the U.S. Attorney, BJ, and the line assistants who were on the case were all called in. It has not moved the case, even though the DAG's office told them to do so. But I was very pleased that we were able to get that appeal heard. So I just say that message out to everybody, that the chain of command is still paying attention to what's going on, and those wheels are still turning should you need to take matters up. And if you have any questions about how that was done, or you want to take a look at the papers that we submitted that definitely caught their attention, please let me know. But in this last year, it's been interesting in the Northern District as compared to Elizabeth. We just did not have a lot of opioid cases. We really were dealing a lot more with insiders in terms of financial fraud cases. So there were a series of insider trading or CEOs who were committing fraud against their own companies. Of course, everybody I'm sure is familiar that Brian and I have a matter that is in the Northern District of Georgia, but interestingly enough, and for good reason, not being prosecuted by anybody affiliated with the Northern District of Georgia. That should tell you what they believe about our case. So I'll let somebody else talk about that one. But, we have been dealing with a lot of public corruption. And so the city of Atlanta prosecutions have been something that has taken up a lot of airspace. It hasn't really resulted in many representations for those of us in the criminal defense bar, but it seems to have taken on a lot of the time of the folks at the U.S. Attorney's Office. One of the things that I'd like to mention about what's going on in Florida, or what's gone on in Florida, just like we were watching a SarahCare, I think a lot of us had been watching the S. Formis healthcare fraud case for several reasons. One, we were dealing with an executive, at a corporate executive high level in healthcare fraud, but also because there were some very serious claims of prosecutorial misconduct. And Brian and I seem to be specializing in cases where we have prosecutors committing acts of misconduct. So I know that we were watching that case very carefully. And what happened in S. Formis is that the magistrate judge refused to recuse or kick off the entire prosecution team, but issued a 120-page scathing opinion about the government's conduct. And let me just tell you like a few things that they did. So when they did a search of, they executed their search warrant, they had hundreds of boxes of documents, correspondence, you name it. And instead of establishing a taint team, they decided, the prosecution team decided that they were just going to have their case agent review the materials and determine what was potentially privileged or not. And so only one box of documents actually made it to a true taint team. Everything else was reviewed by the case agent and at his discretion determined whether something was potentially privileged or not. And whether it was potentially privileged or not, the same case agent and the prosecution team used those documents in reverse proffers with witnesses and people connected to the case. I don't think you get sort of any closer to completely throwing the attorney-client privilege out the door than what these folks did. And so substantial evidence was withheld at trial. It was not enough for Mr. S. Formis to overcome the government's presumption and he was convicted. One thing that was really interesting though about that is we've been seeing a lot of this sort of the government coming out really strong in indictments with ridiculously high levels of projected loss. And there, I believe they had the loss over $1 billion when he was charged. By the end of trial, the range is now between 4 and 8 million. You know, and again, Brian and I have something similar going on. But I thought it was also interesting, even with the celebrities, the Chrisley family. I'm not sure if anybody watches. There's a show with a family, and they've got sort of a very eccentric father, but they were being prosecuted for tax fraud, and there were massive press releases coming out of the office, and then all of a sudden you didn't hear anything. Well, it's because the matter was ultimately dismissed. It turned out that they didn't have what they were saying that they did, and so it's something for us to be on the lookout for, are these super aggressive prosecutions from the government. If we take our time, and I'm talking to the defense bar now, if we take our time and try to just knock it down piece by piece, what precedent in the last couple of years is showing us is that we can actually make some good progress for our clients, because the cases are not as strong as how the government portrays them in indictments.
Jamil, I'm surprised that you didn't mention in the S. Formis case the government lawyer referring to the defendant as a vampire.
Yeah, there's that. Well, you know, one thing I have to say about that is in the appeal that we took up to DOJ, we made use of the press release that the Northern District of Georgia put out, because in that release for our client, the case agent said, this man is a fraudster, and he has defrauded all of them, you know, all of the banks in all of the United States and blah, blah, blah. And so we went to the local rule in the Northern District of Georgia and said, right here, they violated the local rule in their press release. And we probably would have had a stronger argument if the statement came specifically from the prosecutor, like from BJ Pak, as opposed to one of the case agents. But I thought it was a compelling point, because when we raised the issue with the U.S. Attorney's Office, I noted that the first assistant and the U.S. attorney were writing down the local rule number as we cited it. So it seemed to be something that might have skipped their mind for a second, and it was a good reminder to them. But yeah, there's so much in that case that it's surprising. But of course, we all know that in all of the Florida districts, they treat healthcare prosecutions like drug dealers, and it's usually a path to a very quick conviction, unfortunately, in those districts. So, yeah.
So Joe, what about it from your perspective? I know you've been involved in some, higher profile matters, including Reality Winner and some other corporate internal investigations. What are you seeing, at least from the Atlanta perspective?
Well, thank you, Brian. I think Jamila has put together some great materials that, if you want those materials that summarize 2019 in the Northern District of Georgia, and she touches on other districts in her. I do see continuity. Obviously, the three U.S. attorneys, BJ Pak, Charlie Feeler, and Bobby Christine are all in place. Bobby's in the Southern District, Charlie's in the Middle District. Georgia has three districts like Alabama and Tennessee, and I guess many other states do, and Florida. But all three U.S. attorneys still there. I think something Jamila points out in her paper is the addition of lots of new judges in Georgia, and obviously the J.P. Boulay in the Northern District and Judge Steve Grimberg in the Northern District are new judges. So it's interesting to see how they will be handling themselves. I want just one word about press. Having had the Reality Winner case in the Southern District of Georgia in front of Judge Hall, and I came to appreciate that the Southern District has very different rules than the other districts about public comment. I think we obliged everything we needed to do during the handling of that case. I think I see sophisticated cases. Some cases dealing with individuals in the Northern District of Georgia that are being handled out of other districts, like the Southern District of New York and the SEC, in a case that I've been involved with. So that there are those situations where matters involve individuals in the Northern District of Georgia or corporations in the Northern District, where those cases are being looked at by the SEC elsewhere. And I think it's something to keep in mind. I think public corruption just really dominates everything I think about the Northern District, but there's so much else they're doing. But it's been a long wait to see what happens next in those cases, and a lot of fine assistant U.S. attorneys working on those cases. Regrettably, the public corruption cases have not generated a lot of work for those of us in the defense bar in Atlanta. But anyway, it certainly is taking up a lot of time and energy from my perspective for that office, and I think things will continue to happen, I'm sure, right up until and beyond the election this fall.
Well, thanks for reminding us about the new appointees, and your former colleague Jamila and Rick Dean, J.P. Boulay, who was with the DeKalb County Superior Court and was nominated and confirmed in 2019. I do think, as you point out, in the Northern District of Georgia and elsewhere, False Claims Act cases continue to be filed and pursued and investigated with greater and greater frequency, even in the midst of COVID. And I know JD looking to Nashville, and in Tennessee, that's no different. In Nashville, in the Middle District of Tennessee, has had their share of those cases for the last 10 years during your time, and when Ty Howard was there up until today, and it looks like things are continuing.
Yeah, thanks, Brian. Things are definitely continuing apace in the Middle District when it comes to healthcare fraud. I've never added it up, but I think the Middle District has the largest number of FTEs devoted to Civil False Claims Act enforcement outside of the larger districts like Boston and Philadelphia. And there's been some turnover there this year, but all of those positions have been backfilled. And so they are fully staffed up and continuing to investigate. Sort of notably in Civil False Claims Act cases right now in the Middle District, there are at least 2 intervened key TAMs that the government is actively pursuing. One against Arriva, and then another series of cases against a whole slew of defendants originating from a company called Comprehensive Pain Services. And then in addition to that, there is at least one very large non-intervened key TAM that a consortium of Relators Council is pursuing. So in the next year, we're going to see some probably interesting decisions coming out of the court on those actively litigated cases. In addition to that, they have, I would say, the regular docket of under seal investigations currently going on, just judging by activity. On the healthcare front within the Middle District, we're also seeing the continuation of the joint criminal civil prosecution. So on the Comprehensive Pain Service case that I just mentioned, there was a trial last year involving the CEO of that company. His co-defendant pled out, and that there was anti-kickback violations, and he got convicted and ended up sentenced to 42 months and around $800,000 in forfeiture and restitution. And now that case is continuing civilly. So we've seen that. Also in the Middle District, the Middle District is one of the locations of the Appalachian Regional Opioid Strike Force. And so that kind of gets into the more opioid-heavy criminal prosecutions outside of the criminal civil False Claims Act, improper billing, submission of false claims, anti-kickback issues. Some of those fall into the opioid prosecutions, but they're more traditional, opioid-related prosecutions, and we've seen a number of indictments coming out of the Middle District, a number of indictments coming out of the Western District and the Eastern District as well. It is obviously a focus of the department across the country, but particularly here, I know that they are packed to the gills. They have an additional, I think, 3 or 4 prosecutors assigned to this district solely to focus on those cases. So, I think we'll continue to see that. In terms of the traditional white collar bar, I think a little bit like the public corruption cases you were referencing in Atlanta, we don't see a lot of those cases. I mean, those folks are not saving their money, and a lot of them are being represented by appointed counsel. So it's not there's not a lot of particularly sort of interesting decisions or litigation coming out of them. Just sort of clicking through my notes. For those of you who have practiced in Tennessee, Tennessee is sort of like 3 states merged into one. Things are very different in each of the districts, and they each sort of take a different approach to what they prosecute. And just wanted to talk about some of the interesting cases that we've seen this year. Out of the Eastern District, there's a tremendous amount of research and national security interests around Oak Ridge and the national laboratory there. So every year we see at least one sort of intelligence-based prosecution. There was one this year against a former or Chinese national who was accused of stealing secrets from UT and the national laboratory at Oak Ridge. And we expect to see those every year, some kind of national security prosecution. In the Middle District, aside from healthcare, which has always been dominant here, and we always see Ponzi scheme prosecutions coming out of the Middle District, and we had a couple of those this year. One involving a gentleman who created and supposedly ran what turned out to be fictitious solar farms and sold shares to investors. He was indicted on a number of counts and ended up pleading guilty and sentenced to 10 years and about $16 million in restitution. And then another gentleman indicted on securities and mail fraud related to a company called Well City Inc., which was essentially a typical Ponzi scheme offering investors the opportunity to invest in a company that didn't exist. You know, like many of those, there's an indictment and then there's a guilty plea and that's it. In the Western District, you know, traditionally the Western District has not had as many white collar cases, but there were some interesting cases, 2 interesting cases out of there this year. One involving 2 defendants who were indicted for creating fictitious profiles on dating sites and embezzling money from people who responded to their ads. There were a number of unnamed co-conspirators who were apparently offshore and unreachable by the Department of Justice. So sort of an interesting, not run-of-the-mill prosecution. And then sort of a combined Western and Middle District case because the Western District recused. Former AUSA actually was indicted for falsifying her time records. So those of you who remember filling out USA 5, apparently it was much more important than we all thought it was. But I will say that her conduct in there and the description of the conduct was a little bit more extreme than, you know, adding an extra hour to your day and included, you know, certifications that she was in the office when she really wasn't over a number of years.
JD, I always thought that those USA 5 entries were supposed to be inaccurate.
Yeah, I think I was told that they were supposed to be inaccurate. So, but that's another story. In any case, you know, I guess there is a line, and I guess she went over it, and it ended up being convicted of those charges. So that was another interesting prosecution. But that's kind of the lay of the land in Tennessee. You know, lots of activity in each of the districts aside from those cases. And you know, I feel like all the districts are really starting to hit their stride, particularly the Middle District and some of these larger and more complicated healthcare prosecutions.
Well, thanks, JD. I thought for the last, you know, segment of our discussion, we would talk about COVID, both procedurally and substantively, and just remind folks, if you have questions or comments, feel free to punch them into the Q&A at the bottom of the screen. But, you know, COVID has presented all sorts of challenges across the board, and not least of which to judges and litigators who are trying to move their cases along. There's been difficulty with respect to impaneling juries, having jury trials, impaneling grand juries. Erica, what are you seeing in your area about courts and the government response to COVID?
I think Alabama has maybe been a little bit more aggressive, it seems, certainly than Georgia, in getting the courts back up and running. So we've seen grand jury meeting here sort of in a non-emergency way. I know some districts are sort of only taking cases that absolutely have to be indicted. We've seen sort of things back up and running since about June, and they're using sort of a large ceremonial courtroom. They're holding grand jury there rather than the regular grand jury space to allow people to distance and meet on a regular basis. So we are seeing indictments pick up. We've also seen investigative activity pick up. You know, originally FBI, those sorts of offices were not operating at full capacity. They now appear to be, and we're getting back to beyond subpoenas and document requests, people actually conducting interviews and proffers and those sorts of things. We had our first criminal trial here in the Northern District last week, and it was a multi-defendant case, lots of lawyers, and my understanding is that went fairly well from a procedural standpoint. They've had trials in the Southern District, even going back to as early as the spring. I had a colleague trying a fully masked case in Mobile, and they didn't seem to have any problems with proceeding forward in federal court there. So we're seeing trials pick up. We're seeing investigative activity pick up. Our U.S. attorney's offices, I believe in all 3 districts, like the offices where you are, I believe they're all still working remotely. So I've had a lot more prosecutors in my office than their office in a sort of unusual way. I take appointed work as well, so I've seen some interesting things for my more traditional criminal cases in terms of, you know, the use of Zoom for initials, detentions, plea hearings, sentencings is supposed to be based on defense consent. And, you know, I've had numerous situations where I was appointed to represent somebody. They were located in a different part of the state than me. You know, we're giving a Zoom hearing and it's like, well, do you consent, right? At which point you don't have a lot of options. So we are seeing the courts sort of really push on remote hearings, and only when the defense bar is pushing back and demanding in-person hearings is the court really agreeing to that. If you ever represent any incarcerated clients, we've also still got the majority of our federal holding facilities not allowing in-person attorney meetings. So that's creating a lot of new procedures in terms of how to get documentation to clients, how to show discovery to clients. And there doesn't seem to be a lot of concern about speedy trial because the Northern District only has 1 courtroom that it's currently using for trials, whereas normally, I believe there are 9. So you can't get anything on a trial docket because there's simply not space. The judges are having to sign up as to who gets to put trials in that space. And so we're having difficulty just getting matters set. And then on the compassionate release front, I know that we've all been sort of dealing with that. We have found the Alabama judges not to be overly receptive to compassionate release motions. And I think even more troubling for me, not overly receptive to COVID-related arguments with respect to detention in terms of pre-trial detention. So that has been, I think, disheartening for the defense bar here. So we're really in a situation with my white collar defendants. It's actually been a boon, as I'm sure it has been to many of yours, which is sentencings have been pushed out, plea hearings have been pushed out, self-reporting dates have been pushed out. You know, people have gotten almost an additional year with their families that they may not have gotten. And, you know, I had a prosecutor, not to be named, that told me the other day that, you know, if you ever wanted to pitch for a non-incarceration sentence for a white collar defendant, this was the time, right? That they were making deals that they had not made before. So it's business as usual in Alabama, that things don't seem to be stopping, but I think it's going to be incumbent on us as the defense bar to continue to push back, because in places where we're pushing, I think we're preserving some of those fundamental issues. In places where we're not, both the courts and the prosecutors are happy to sort of move things along remotely and skip over some of those critical steps, even though we've got court orders in place that, again, discuss defense consent. So,
well, Erica, you raise a lot of very good points and issues that I know that will continue to be litigated, especially, you know, the compassionate release issues. There are, of course, confrontation issues with, you know, if there are going to be Zoom trials and how that may work. And of course, for, you know, in custody pretrial detainees who are subjected to extraordinary extraordinarily long waits is something that we hope will be rectified as we go forward. I mean, Jamila, JD, any other observations before we talk about some substantive COVID response?
Yeah, to Erica's point about the folks who are unfortunately detained pre-trial, one thing that I have found to be helpful is actually being able to have Zoom sessions now. And so we've been able, with most of the defendants in the Northern District of Georgia, housed at Lovejoy, which is about an hour and 15 minutes outside of Atlanta. But now we're able to communicate with the staff there and actually schedule Zoom sessions to sit down with the client and go through the discovery and talk about trial strategy. And so that's actually been a benefit where sometimes it might be too difficult to get down there or just, you know, other obligations. And the clients have seemed to be really paying attention and have their discovery pack of all their documents ready. And so we've seen that. For our district on arraignments, it's a little bit different. You have to have a waiver form actually completed, Erica. And so I had an arraignment in person because the client is down at Lovejoy, and by the time they set the arraignment, there was no way I could get a document down there and back. And in Northern District, there were probably 20 cars in the large parking lot for the entire building. I mean, it was really quite empty when I was there, and it just so happened that we had the duty magistrate judge handle it, and it was super quick. But they also had already put up plexiglass in front of the podium and in front of the judge and the clerk. So they've been making arrangements, you can tell, to be able to start to open up the court a little bit more.
Thanks, Jamila. You know, obviously, in addition to these procedural issues, there's been a lot of COVID-related fraud, right? On March 16, 2020, AG Barr directed all U.S. attorneys to prioritize the investigation and prosecution of COVID-19 related fraud schemes. You know, we've seen, you know, anecdotal incidents of that throughout the country. Here in Georgia, the governor, the state AG, and the 3 U.S. attorneys created a state and federal coronavirus fraud task force. Like many other states, you know, Georgia has been a recipient of billions of dollars in CARES Act funding. I know in Florida, they have had instances in which people have been prosecuted for, you know, PPP loans, et cetera. On March 22nd, the DOJ filed its first COVID-19 related fraud action in Austin, Texas, where they got a civil restraining order against the operators of a website called www.coronavirusmedicalkit.com, where it sold fake vaccine kits. No word on whether the Russians were tied to that website or not, but there is a number of instances of both fraud and price gouging and hoarding. We spoke on a panel with the District of New Jersey, United States Attorney Craig Carpenito. They've been very active in going after both price gouging and false personal protective equipment. So that's something that, you know, I think we'll continue to see as long as, you know, COVID is with us. On a related note, you know, there have been a number of nationwide telehealth prosecutions, including in the Southeast. And my colleague, Grace Zoller, has been kind of on the front lines of that stuff for our firm and tracking it and representing a number of clients. And the telehealth prosecution started off a couple of years ago with Operation Brace Yourself, where the DOJ did a national takedown involving telehealth and DME, which focused on the absence of medical necessity. It was really just an evolution of the, you know, the DME scheme that we're all familiar with. But more recently, in, I believe, April, the DOJ announced the Operation Double Helix, which had to do with telehealth and genetic testing, which they found to be medically unnecessary. Fast forwarding to now, where the focus on the federal government as it relates to telehealth seems to be on COVID response. And the telehealth practitioners offering, whether it's phony testing or testing using the wrong codes. I mean, I think, throw it out to the panelists, but, in terms of healthcare fraud investigations and prosecutions, while there are a number of great things and opportunities about telehealth, and I believe in many ways, that will be the future. It's also ripe for fraud.
Yeah, I agree. Brian. One thing that I might also add to that is we're probably going to see more civil False Claims Act investigations and work in the coming months, because if you think about like skilled nursing facilities, right, where especially in New Jersey and Seattle, we all see in the news these large outbreaks, and I think that there might be a tendency for the government to say, well, can we say that the care that was provided to all of those folks, whether it be for Medicare or Medicaid, really it met a quality that is quality standard that would be sufficient to support the claims. And so I think there probably will be some AseraCare likely retread, Erica, right? With these nursing homes that have had some really horrible outbreaks with COVID and fatalities as well. So just on the other side, I think that there'll be a lot more, and also take the quality of care out of it. There will also be civil FCA cases related to a lot of these facilities that received funds, from the CARES Act and how they've actually administered those.
Yeah, that's a great point. Our U.S. attorney here in Nashville took it upon himself to send letters to every skilled nursing facility that reported a case of COVID in the Middle District saying, we expect you to do the right thing and care for your patients, which, as you imagine, getting a letter out of the blue from the Department of Justice saying, we expect you to do the right thing and we're worried maybe you're not, even though they don't know, generated a lot of consternation among some clients. So there is a definite laser-like focus, I think, especially in the skilled nursing facility. I mean, quality of care and services provided is definitely a focus of the civil division, civil frauds in the skilled nursing facility context. So I think COVID is just another overlay. And then to your point, Brian, on the telehealth front, yeah, I mean, certainly there's this sort of willful, we're going to prescribe testing that people don't need, and we're going to have a boiler room of doctors, and they're just going to call and call and call. But there's also the telehealth companies that say, hey, you know what, we don't really care about state licensing requirements, or, we were acting under a waiver that was provided, but that waiver is expired, and we're going to go ahead and just, not really worry that we've got an Ohio licensed doc calling all these different states. And somebody's going to realize that that's not okay and file a QTAM. And increased reimbursement for telehealth is going to make it much more attractive to Relators Council to do that. So I think, we've definitely seen that. I've seen that from sort of across the board companies not having their ducks in a row on the licensing front as they're trying to stand up these giant telehealth platforms to individual providers who are calling saying, hey, I'm retired, but I have this opportunity to work for a telehealth company, and I've been seeing patients in this state that I'm not licensed in. Is that okay? So it's out there, and yeah, I mean, I think we're going to see sort of years of this working out.
And a couple of questions from the audience. Someone did ask about my tongue-in-cheek comment about USA 5 being inaccurate. I probably shouldn't have joked about that, but where that comes from is USA 5 was historically used for budgeting purposes, and people were sort of told to make sure they filled out their USA 5, even though you're a salaried employee, you have to fill out these hours, but not too many hours. So there was just some gamesmanship about it, but of course, never did anything illegal. Carol Rose wanted to just let folks know, if it's okay with the panelists, if people would like to take a look at the materials, I think we can send those out, recognizing they were drafted kind of pre-COVID, so it's mostly pre-COVID materials. And then my colleague Kevin Coffey in our Chicago office asked a question about what we've been talking about, continued focus on healthcare fraud and abuse prosecutions. And one thing I think we all fear and our clients fear is kind of a similar reaction what we had after the mortgage crisis, right? When you have all these loans going out, you have a task force being created, you have SIGTARP being created, whose sole job it is to go out and detect this type of fraud. And, if and when, we get past COVID, I think we will probably see a similar response from the DOJ.
And Brian, I wanted to raise that question. We talked about the healthcare piece, and we've talked a little bit about, fake products and things of that nature, but we haven't talked much about the loan fraud piece. And, at least what I've been seeing around the country at this point, it seems like DOJ is going after low-hanging fruit, very, very blatant fraudulent W-2s, fraudulent employees.
People buying Lamborghinis with their PPP proceeds.
So I was just curious if anybody else was seeing anything that was maybe a little bit more nuanced, because I do think if the SIGTARP experience tells us anything, that, you're going to ramp up these task force, you're going to have all these agents who've got to have something to do. And we're going to move from a place where we're talking about Lamborghinis and 500 fake employees to, maybe the financials were a little off. Maybe you needed 4 million and not 3, So I was curious if anyone was already seeing that. I have not seen it yet in the 3 Alabama districts. It appears that, again, their focus is still on the low-hanging fruit. But I'm curious.
I think that's a great point, and I think it totally makes sense to go after the low-hanging fruit first, right? And rightly, this money was sent out quickly, probably too quick under normal circumstances. But I think there was a real effort, a bipartisan effort, to get money out into the world to those who needed it. But as you point out, Erica, it's also being misused by many that don't. And I do think we'll see for the coming months and probably years an analysis of whether the services were necessary, right? Whether they were delivered to the level that they should have been and what they were paid for and those types of things. Jamila, JD?
Well, I think that, one interesting thing, I think we're going to see a real bifurcation in prosecutions and government interest. One is, we're going to go from the low-hanging fruit, buying out Lamborghinis, to, hey, you said you kept 300 employees on the payroll. You really only kept 250 now that the SBA has come in and audited your loan because it's over the threshold audit amount. I think that's one side, right? And that may fall into the kind of criminal basket and be a little bit more nuanced. But on the other side, with some of these larger loans, that certification is so mushy that I do not see most criminal prosecutors wanting to touch it unless there's a number that's just wrong. And everybody knew it was wrong.
Yeah.
And so, but with some of the larger loans, I think you could see some interest from Relators Council. You get over $5 million, they say, hey, this is something that might be worth it. Or some creative ideas about putting together, an LLC or consortium of supposed relators, an entity relator that then goes and looks at loans and says, these companies in this in this particular area, in this particular type of business didn't need the money because those companies did fine, but they still took the loans and file in a larger scale key tam. So I think it's really going to bifurcate, but I do think it's going to be really fascinating to watch as it plays out over the next couple of years.
I think that's a very good point. And, just a minute or so left. Any final thoughts on anything else that we might see from you, Jamila, or you, Erica, or Joe, going forward?
No, just glad to see everybody. I know that we all miss the conferences, miss the in-person meetings. To the Alabama folks that are out there that I normally see on a regular basis, I miss seeing your face. Let's go to lunch, please.
Well, and thank you everybody for joining. I just want to revisit one thing, which is our Southeastern program. I really wish we were on our way to Chateau Elan this afternoon, but I really have enjoyed being a part of that program, and just want to reiterate the credit due to Joe Whitley and Mitch Mitchelson, who were really the drivers behind the thing, going back 8 years ago when the ABA asked for folks to do more regional programs. It was really Mitch Mitchelson's brainchild to do the program, and he brought so much energy and enthusiasm and ingenuity to the thing for so many years. And it wouldn't be what it is today without Mitch and certainly Joe. So I appreciate everything those guys have done and everyone else that's here today participating in the past. And like you said, Eric, I really hope that, you know, people can come out next year in person and actually enjoy one another's company. So thank you all. Thank you to the panelists. Thank you, Joe, and thank you to the ABA and for all who attended here today.
Thanks very much.
Thank you.
Be safe.
Bye-bye.